Today, we have the great pleasure of hearing from Ms. Terry Dandy. She's the Outreach and Education Program Manager for the U.S. Equal Employment Opportunity Commission, EEOC, for our Atlanta District Office. There, she educates workers on their employment rights, provides training and assistance to employers on EEO compliance. She also coordinates annual outreach and training programs, and then she partners with different organizations to promote and advance equal opportunity in the workplace, such as us here at DeKalb in NAACP. She has over 20 years of experience with EEOC, 14 of those. She was actually working with the EEOC headquarters in Washington, D.C. She is a certified mediator and career coach. She has a plethora of awards and recognition for her works. This includes the 2022 State of Georgia Equal Opportunity Award from Governor Brian Kemp. And she's also received the NAACP Georgia State Conference President's Award. So great accolades, Ms. Terry Dandy. Thank you so much for joining us today, and we definitely look forward to hearing from you. Thanks.
Well, thank you, Tawana, and thank you, President Hammonds and the DeKalb NAACP membership for having me here today. Is my audio pretty good? Can you all hear me loudly? Yes. Great.
You're good.
Thank you. Thank you. So I always appreciate the opportunity to advance equal opportunity in the workplace and to partner with such strong organizations as the NAACP. We've definitely been partnering with the NAACP for years and doing specific educational programs for various branches throughout the state. Again, I'm Terry Dandy, Outreach Program Manager. I appreciate Tawana reaching out to me and coordinating this opportunity. I understand that I have about 20 minutes. I have a number of slides. I will go through them pretty quickly. What I really like to do is hear your questions and engage on matters of concern to you all. I know from what you mentioned earlier, President Hammonds, that employment is one of those areas of particular interest for the NAACP, because we know that is a space in which discrimination, unfairness, equity issues come to play. And so what I'm going to be talking about today is the foundation of all of that. I mean, we hear about diversity, equity, inclusion, and belonging and things like that in the workplace, but at the root of it all are the laws that protect against employment discrimination. So it's important for folks to know what those laws are so that they can exercise their rights constructively in the workplace. So I'll start with just a little bit about the EEOC, which I'm sure you all are very familiar with. So next slide, please. Simply, the EEOC was born out of the landmark Civil Rights Act of 1964. We opened our doors a year later. So that law established the EEOC because during that time, we recognized that discrimination against Black folks were occurring on a regular basis. And in order to address those issues and attempt to change behaviors in the workplace, many of the laws were established and others have evolved over the years and come into play as well. So the EEOC is the federal agency that enforces the laws that protect against employment discrimination against workers and applicants. Our mission is to prevent and remedy employment discrimination and advance equal opportunity for all in the workplace. The EEOC has 53 field offices throughout the U.S., 2 of which reside here in Georgia, 1 in Atlanta and the other in Savannah. So we handle those complaints within our jurisdiction. And the EEOC Atlanta District Office jurisdiction includes the entire state of Georgia and 12 contiguous counties considered low country in South Carolina. As you all know, we receive and resolve complaints of employment discrimination through a number of different ways, one of which is mediation. And with a mediation, both parties, meaning the charging party and the employer, must agree to voluntarily participate in a mediation process. If both parties do not agree, then we don't enter into mediation. Conciliation is another way in which we resolve disputes, and that is when it enters into an investigative process and the investigator determines that there may be room to negotiate or bring both parties together to resolve the matter. If it's not resolved through conciliatory means, then a notice of right to sue is issued to the person that brought the complaint. And that person, the charging party is what we call them, has 90 days to file suit in federal court. If we go through a full investigation, as you all know, that can take some time, whereas mediation generally takes about 6 months or so. An investigation can take longer because we're actually trying to ferret out the facts of the case and make a determination as to whether or not discrimination occurred, and that takes time. And from time to time, we may approve a case for litigation, and that is where our legal unit come into play and file a lawsuit against an employer and attempt to resolve it there. And lastly, as you can see, we provide training to employers as well as general outreach and education to the public. Next slide, please. So you all are probably familiar with this poster. Most covered employers, all covered employers should have this poster in their facilities, work establishment, and a common place, excuse me, where all employees can see the poster. Equal employment opportunity is in fact the law. It's not civility in the workplace. It's not the nice thing to do. It's not optional. It is indeed the law. So if you're a covered employer, you must comply with the law. I oftentimes hear from workers that Georgia is an at-will state, and from that they deduce that they have no rights in the workplace. But the exception to at-will are one, civil rights in the workplace, which are the laws in which the EEOC enforces. And then on the other side of this screen, you'll see Know Your Rights poster, which is a relatively new poster for the EEOC. Next slide. So what are the protected bases under federal law by which an employer cannot discriminate, harass in the workplace? It will be these that you see on the screen. Race is basically the racial group in which an individual identifies. Color is different from race under the laws that the EEOC enforces. Color is the sheer complexion and pigmentation of one's skin, and people within the same racial group can discriminate against each other based on color. Religious-based discrimination is also covered under the law, and with religion, persons can request an accommodation for their religious beliefs, and employers must provide those accommodations or requested accommodation unless it imposes an undue hardship for that employer. Similarly, with disability type discrimination, which includes both physical and mental disabilities, could also be learning disabilities. And what I want to convey about disabilities, which is covered under the Americans with Disabilities Act, is that oftentimes when people hear the word disability, they assume that it's a condition that is one of a permanent state, like a hearing impairment or being blind or being in a wheelchair. But under the law, a disability is any medical condition that substantially limits one's ability to carry out major life activities or major bodily functions. And that includes a whole range of medical conditions. So I like to refer to it as a medical condition. So major life activities could be standing, of course, walking, talking, caring for oneself. It's just a range of things. And also under the Americans with Disabilities Act, a disability can be one that is transitory, episodic, is not a permanent state. So when a condition, let's say, is at its worst, it could substantially limit a person's ability to do major life activities. So it could be arthritis, it could be diabetes, it could be cancer, it could be migraines, it could be respiratory type issues. It's just a range of conditions. And under the Americans with Disabilities Act, an employer must also provide a reasonable accommodation unless it imposes an undue hardship. So what qualifies as an undue hardship is something that is too expensive for the employer to implement or disruptive to the work environment, or perhaps may create a safety concern for other employees. So the disability law, we've been seeing an increase of charges related to this. And what we're finding is that employers are not necessarily providing reasonable accommodation. Now, if you have a medical condition that is not visible, which, by the way, most disabilities or medical conditions, as I like to refer to them, are indeed invisible. So an employer can request that you provide medical documentation for such conditions in order for them to respond appropriately. But the issues that we're seeing around disability discrimination has to do with reasonable accommodations. And one of the most requested reasonable accommodation is often leave, requesting and needing time off, either for treatments or because you're not particularly feeling well. So leave can, in fact, be a disability, along with a whole different range of other ways. I'm sorry, leave can be a reasonable accommodation, along with a whole other range of options. So other protected bases include nationality, national origin, a person's birthplace of origin, genetic information, which is one of the newest laws that came into place under the Genetic Information Non-Discrimination Act in 2008 or 9, I believe. And it basically says an employer should not be collecting or using genetic information in making employment decisions. Now, what constitutes genetic information could be information gleaned from genetic testing. I know that sounds far-fetched and out there, but surprisingly, I mean, people would be surprised to know that genetic information is often captured in things like Ancestry or 23andMe, and sometimes folks post things on their social media, and employers could inadvertently or intentionally retrieve that type of information. Other genetic information would be a person's family medical history, like the forms that you complete when you go to the doctor's office and they ask if anyone in your family have ever had this condition or that condition, because from that information, it gives insight into the potential, if you will, of another person in that lineage sharing that same type of condition. So that is pretty much what amounts to genetic information. Other protected bases, of course, include sex-based discrimination, which includes pregnancy, sexual orientation, gender identity, sexual harassment, and just overall sexual sex bias, preferring one sex over the other. Retaliation is prohibited along all of these protected bases. And if that provision was not in place, then folks would not feel comfortable complaining about discrimination, and the EEOC would not be able to carry out its mission. So the law protects workers and applicants from being retaliated against for having exercised their right to complain about possible discrimination. And then also you'll see that age discrimination is covered under the Age Discrimination Employment Act. The important thing to remember here is that that particular law applies to workers and applicants that are age 40 and older. So that's a general overview of all of the protected bases. On the next slide, if you would, you'll see the laws that correspond to each of these protected bases and the number of employees that an employer must have in order to comply. So most of these laws, as you could see, apply to employers with 15 or more employees, with the exception of age discrimination. An employer must have 20 employees. And of course, the Equal Pay Act, there is no particularly set limit. And the Equal Pay Act essentially says that men and women performing the same work in the same establishment under the same conditions and the work is substantially equal, then they should be paid the same. And not only do we see pay disparities based on gender, but we see pay disparities in the workplace based on race, based on whether or not a person has a disability, based on nationality. So compensation discrimination is across the board. Next slide. So the laws that the EEOC enforces, if you're a covered employer, would apply to you. Basically, private employers, government agencies, labor organizations, staffing companies, employment agencies, all of these that are listed here on the screen are considered covered employers. If you are a federal employee, then the process is very different from what we're talking about today. For federal employees or someone applying for a federal job, you must first file with that agency. You cannot come directly to the EEOC. You have to file with that agency, and you have to do so within 45 days of alleged discrimination. Protected individuals under the laws that we enforce are these that are listed here. Of course, employees, job applicants, because we know that discrimination occur in the hiring process, recruitment process, how employers may advertise a job from time to time. May also apply to temporary workers, seasonal, part-time, as long as there is an employee-employer relationship. Again, the EEOC handles employment discrimination only, so the discrimination must occur in the employment arena. Next slide. To talk a little bit about retaliation, because, excuse me, retaliation generates the most complaints to the EEOC. Normally, retaliation charges are concurrent charges where we see perhaps someone complained about discrimination and some type of retaliatory or punitive action was taken against an employee. But it is unlawful to retaliate against an applicant or an employee for the reasons that are listed on the other side of the screen, which we call protected activities. So if someone complains about what they believe to be employment discrimination or file a charge with the EEOC, that's considered protected activity by which an employer should not retaliate. They cannot retaliate against you for requesting a reasonable accommodation or complaining about or notifying a manager or supervisor about possible harassment, participating in an EEO type proceeding, refusing to follow orders that may result in discrimination, resisting sexual advances, or intervening on behalf of others. And also you cannot be retaliated against for asking about pay and salary and what someone else may be getting paid of a different race in order to determine whether or not there's some fairness in that process. An employer cannot retaliate against you for that inquiry. Now, they're not required to provide you with a response, but they should not retaliate against you for the inquiry. Next slide. And these are just a few examples of retaliation. Oftentimes we think that retaliation is just something that results in termination, but it could also be denying someone a promotion, issuing unjustified negative evaluations, negative references, demotions, harassment, and things of that nature. Next slide. Here, I just want to share a few examples of workplace harassment because we continue to see a number of cases of harassment. Harassment in the workplace is not just sexual harassment, which is what we tend to hear about most in the media and the public discourse sometimes, but there is harassment based on race, based on age, disability, religion, nationality. And so here you'll just see a few examples of workplace harassment that is prohibited. Any type of harassment or bullying that occur in the workplace and is based on one of those protected bases that I mentioned earlier, then that violates federal law. Harassment is indeed a form of discrimination. Next slide. So the next, the next few slides, excuse me, talks about disability, which I pretty much already covered. One aspect of disability that I didn't cover is being regarded as disabled. This is covered under the ADA. This is where someone is perceived as having a disability, but don't in fact have one, but they're being treated as if they do. Let's say that you had a medical issue or emergency, you know, a few months ago, and your employer, manager, supervisor, agent of the employer is treating you as if you're not able to carry out your job because of this medical emergency. And maybe they are removing certain responsibilities or demote you because of it. And sometimes there's constructive discharge involved where they're taking these actions for the purpose of ultimately discharging you. So if an employer is regarding you as disabled when in fact you're not disabled and you're being denied employment opportunities because of it, that too is covered under federal law. Next slide. So here, I mentioned this earlier, is just what constitutes undue hardship. That is the only defense for an employer in not providing a reasonable accommodation. Next slide. There are certain policies under the Americans with Disabilities Act that are considered exclusionary and have a desperate impact on people with disabilities. And we've seen some of these in the workplace. And they're kind of called 100% healed policies, where an employer expects you to be 100% healed, if you will, to return to work. This policy violates the ADA because it does not allow for a reasonable accommodation should one need an accommodation. Another is a maximum medical leave policy, which basically says that, oh, once you exceed this, let's say an employer's maximum leave is 60 days. And once you exceed that 60 days, then we terminate you. That type of policy, again, have a desperate impact on people with disabilities, and it would violate the ADA, along with time and attendance policies that disproportionately impact people with disability. Next slide. These are just a few cases that the EEOC has settled, disability-related cases, and most of these involve reasonable accommodation issues or one or more of the exclusionary policies that I just mentioned. The Lowe's case was definitely one of those that had a rigid leave policy, and some may think that if you exceed your time under the Family Medical and Leave Act, FMLA, that then an employer could terminate you. But the FMLA and the ADA are two separate and distinct laws. And just because you exceed that time or you've used up that time doesn't give an employer the right to terminate you. You still have to, an employer still have to engage in an interactive process to determine ways in which they can accommodate a person with a disability. Next slide. These are just some of the tips that we give employers that I wanted to share with you all. And of course, they should not be considering medical conditions in making employment decisions. Employment decisions should be based on job-related factors and criteria like abilities, qualifications, experience, skill sets, job-related type things. Employers should not be asking during an interview about medical problems or situations. They have to ensure that their policies and practices do not disproportionately exclude people with disabilities. They should take requests for reasonable accommodations seriously and seek to accommodate, unless again it imposes an undue hardship. And of course, provide reasonable accommodations. And they may also ask for medical documentation. Next slide. There is a new law that will take effect June 27th. It's called the Pregnant Worker Fairness Act. And it basically would allow pregnant workers to seek a reasonable accommodations for known limitations related to pregnancy, childbirth, or related medical conditions. More information about that is available on our website. Next slide. So the laws that the EEOC enforces apply to virtually all aspects of employment, not just hiring and firing, but everything that you see here. And this list is not all inclusive. So pay, training, assignments, because these types of things help position people for advancement in their career. So if they're being denied training opportunities, mentorship, coaching opportunities, whereas others who are unlike them are granted these things, that too can be a form of discrimination. So consider the full spectrum of employment when thinking about these issues. Next slide. So essentially the laws that EEOC enforces afford workers and applicants certain rights on the job, and those rights are to work without being discriminated against or harassed, to complain about job discrimination without retaliation. Medical information should be maintained and kept private. It's not something that should be shared broadly within the workspace. That is considered confidential information. And then, of course, to request an accommodation for disability or religious purposes. Next slide. Next slide, just to share a few EEOC cases and settlements. These are cases where lawsuits were filed, so we get to talk about them publicly. Matters that are resolved in mediation or investigation, we do not share. That's confidential among the parties. But if a lawsuit is filed, then and settled through a lawsuit, we can share this information. So these are just some examples. When you see $20 million type settlement, those are typically class cases. And there are limits on settlements based on the size of the employer. So just to point out a few here, you can see Jackson National Life Insurance. This was a case where there was discrimination and harassment against female and African-American employees. And you could see the impact of the discrimination in promotions and pay, and folks were retaliated against for having complained about it. You see examples of sexual harassment. These are class cases. And anytime a manager or supervisor is involved in harassment matters, that presents almost an automatic liability for an employer because they're the agent operating on behalf of the employer and expected to know better and do better and should not be engaging in harassing behavior. You'll see also, let's say, checkers, EEOC sued checkers for pay discrimination because they were paying their female managers and cashiers less than their male. Dollar General, lawsuit was filed against them for age discrimination and retaliation. Comments like these, grumpy old men wanted to hire millennials, younger folks, and then in fact, the actions that follow demonstrate that, shows a pattern of discrimination against older workers. Next slide. These are just a few other examples. As you can see, the first one was a case of racial harassment. This was an individual case where, derogatory comments toward African-American employee were made and action were not taken to correct or address those matters. And then there was also an issue of retaliation. So we see a lot of retaliation complaints. Like I said, they tend to be concurrent. D&K paid $20,000 for pregnancy discrimination, where they terminated an employee for when she disclosed that she was pregnant. That violates the law. If an employer tells you to come back after you've had your baby, that violates the law because that shows that the decision is being based on the fact that you're pregnant and not on job-related criteria. And so you can see some of the other examples here to include examples of discrimination against transgender employees. And I believe there's a last one down there that had to do with sexual orientation. Next slide. So what should you do if you believe you've been discriminated against on the job or harassed on the job, which is again a form of discrimination? You should document incidents of discrimination to include who, what, when, where, why. These types of things just help you to recall and recount incidents and what took place. You should tell someone, your supervisor, general manager, if those are the perpetrators or parties involved, you should go to your HR office. This gives the employer an opportunity to address the issue internally. And it could also bolster your case if you did complain and no action was taken. Because when an employer knows about these things, they should take appropriate actions to address it. And if you file a complaint internally within your organization and you don't hear back and nothing is happening, of course, you could always come to the EEOC. You don't necessarily have to complain within your organization first, but again, it could potentially strengthen your case if you do and they don't take appropriate action. Always remember that retaliation too is prohibited under federal law. And most, generally speaking, workers or charging parties have 180 days from the alleged date of discrimination to file with the EEOC. That time could be extended to 300 days in the state of Georgia if you work for a state agency, because there's also the Georgia Commission on Equal Opportunity that does essentially the same type of work that EEOC does, just at the state level. And we partner very closely with the Georgia Commission on Equal Opportunity. Next slide. Of course, you all know that we've been accepting charges online now for several years, and we continue to receive charges this way. And one can schedule an appointment and interview with an investigator through this EEOC public portal. If you have any issues with the public portal, I am happy to share who you can contact with that. I'm happy to put that in chat. Next slide. This is just some of the information that would be needed in filing your charge. Of course, we need to know basic information, name, address, telephone number, the best way to reach you, employer information, name, address, telephone number to the extent that you know all of this information, number of employees, because that help us determine our jurisdiction. And you could just say it's more than 15, because most of the laws we enforce require that an employer must have 15 or more employees. So you don't have to have a precise count. You just need to know that it meets that minimum number. Dates of the alleged discrimination, names of persons involved, what bases are you alleging the discrimination. What I would encourage is that you don't check all, because that's kind of difficult to kind of ferret things out. What is the strongest point of reference in terms of the discrimination? Now, could there be intersectional type issues and bases? Absolutely. We've seen race, sex, and retaliation. We've seen age and disability. So yes, that is highly likely. And any supporting documentation or witnesses that you may have. And if you don't have any, that's fine too. The EEOC would collect it, but to the extent that you can come with some of that information would just be helpful in terms of strengthening your case and starting it. We look for those types of things. One of the handouts that I shared with Tawana that she's probably dropping in chat is one that says focus on facts, not feelings, because oftentimes folks come to the EEOC understandably with very strong emotions and feelings about how they've been treated in the workplace. But at the end of the day, what is needed to help prove discrimination are facts. And to the extent that you can come with those things, it just bolsters and strengthens your case. Next slide. These are the remedies available where we find discrimination. Monetary relief could be compensatory or punitive, reinstatement if someone was wrongfully terminated as a result of discrimination, a promotion if someone was denied a promotion because of discrimination. These are just a few examples. The relief will depend on, relief and remedies will depend on the facts of the case, what's involved and needed to resolve it, to make a person whole. Next slide. These are just final thoughts, just to reiterate what has already been said. In the following slide is just some additional contact information. And I am happy to take any questions that you all may have.
Thank you, Terry. Steve, are there any questions in the chat?
I don't see any questions, but
Well,
see some comments saying that it's a great presentation.
Well, I've got a ton of questions, so I'm glad you guys are not asking questions. I could just get all mine answered. First, I want to ask Tawana, I see the complaints that come in. Tawana, just talk a little bit about the process and how many complaints we get are job related.
So the process for legal redress, we do have a discrimination form on our DeKalb website. So we ask for your name, the incident, the county, because if it isn't DeKalb, we of course try to make sure we get you to the right chapter to be able to assist, details, and if you've reported this to anyone. And then we of course provide the information for EEOC. This year, we haven't had as many reports of issues related to employment, but I will say last year, about 25% of the complaints that we did get in were related to job incidents. So people understanding the process, making sure to accept the interview and turn in. And there was one that I actually did reach out to Ms. Dandy for in regards to a school teacher being discriminated against with the being able to work remote versus teachers coming back and working in school. So that was an interesting one that kind of slowed down. So thanks, Ms. Terry, for helping with that and making sure we get the process along.
Okay, so now thank you, Tawana. Miss Dandy, here are my questions.
Yes, sir.
What about hair discrimination? I think there was a bill in Georgia legislature, so I don't have any. So what if my employer has got this hair thing and they discriminate against me because I don't have any hair?
Mhm. Well, there is a law in some states have passed it, called the Crown Act. I don't know if you're familiar with that. And it is essentially, it kind of came about because of natural hairstyles, if you will, African-American women in natural hairstyles. And Georgia, of course, doesn't have a law in place. And at the federal level, we don't have a quote unquote Crown Act, but under Title VII, race discrimination, when you think about characteristics that are associated with certain racial groups, then hairstyles could be a form of race discrimination. It could also be a form of religious-based discrimination. If certain religions require, like Rastafarian, to wear your hair a certain way or to wear a hijab. So certain things, if there's a nexus or connection to any of those protected bases that I mentioned, then it could qualify as discrimination. And in fact, there was a young lady who told me that she had an interview over the phone because of the nature of the job was customer service, and phone etiquette was a big part of it. And she was offered the job. And when she showed up for the job, the job offer was rescinded because of her hair. Now that's a clear example in case natural hairstyle that they thought didn't fit in to the work space.
Okay, well, thank you. Here's one for you, Ms. Dandy. I'll fill out the application and I said, my employer doesn't like me. Is that factual enough?
No, sir.
The reason I asked that is when Tawana gets the complaints, one of the questions on the form is describe how you've been discriminated against. And that is such a hard question for people to answer. And it really does sort out a lot of feelings, but people do ask the question about, how have I been discriminated against? And it sounds easy to describe it, but a lot of people find it difficult to describe.
Thank you for saying that. I think it's just more education that's needed, more outreach education. We're always eager to partner and to be among the community and to educate workers about these things. One of the handouts, as I mentioned earlier, that I shared with Tawana that you all can certainly make part of your process is focusing on facts, not feelings, because it kind of walks you through some of the things to kind of think about if you're going to file a complaint of employment discrimination. EEOC is a law enforcement agency. Like any other law, we have to be able to prove or determine that a law has been violated. And a simple statement of we don't get along, they just don't like me, that doesn't, we can't enforce that.
Okay. I don't mean to laugh, but we get so many of those coming through that now a lot of cities, counties, and states have ethics boards. How do you work with ethics boards? Do they have to resolve the case first before it comes to you? Or, because a lot of, like in DeKalb County, we have an ethics board. So if an employee has an issue, they could take it to the ethics board. Would they do that first before coming to you, or can they come to you first, or all at the same time?
I don't know the specifics on that. I mean, an ethics board, that sounds like a process that they're using or going to first for some redress. Just be mindful, there's a statute of limitations for bringing complaints to the EEOC. So you don't want that time to expire. If they want to do the ethics board concurrently with the EEOC, then they can, I'm presuming they can do that as well.
Okay, and let's see here. You talked about sexual harassment. So I get a new suit and I'm going to work, and a female employee says, "Man, you look really good today." I mean, is that harassment, or is it how I interpret what they say to me?
Sexual harassment, there are a few standards when it comes to sexual harassment. So first, sexual harassment is unwelcome conduct of a sexual nature that is kind of demeaning, offensive, what have you. Sexual harassment is, as you acknowledged in your example, is not just physical, inappropriate touching, cornering, groping, all of that kind of stuff. It could be inappropriate emails, pictures, gestures, comments of a sexual nature. The standards involved in harassment is severe and pervasive. Is that a statement that is severe or pervasive? And the other standard is reasonable person, that a reasonable person would say that's harassment. So based on those standards, I would say no.
Okay, so let's, Ms. Dandy, any closing comments, and we'll get on with our meeting. But
well, one other thing that I wanted to mention is the use of background checks in employment, because they tend to disproportionately impact people of color. An employer should not have a blanket policy or statement that says, we don't hire anyone that has a record. That would violate Title VII, because again, that has a disproportionate impact on people of color. The cloak language for that is a clean record. One must have a clean record, which generally oftentimes mean no blemishes, nothing on your record. That too can be problematic for an employer. What workers should know is that those types of screenings and tools can result in race discrimination and discrimination based on nationality. What employers are advised is that they must look at whether an offense is job related, if it has any relation to the job, how long ago it's been since the offense was committed, and whether or not the person has been, gainfully employed and things of that nature. So there are factors to look at, and there are many employers now, particularly larger ones, that have second chance type programs. And you all may be familiar with the Georgia Justice Project, who's been working very just strongly in this area for many years, and have made a lot of good headway legislatively here in Georgia in terms of formerly incarcerated individuals and their rights, particularly in the employment arena, because we all recognize that that is a center need in terms of avoiding and mitigating recidivism.
Ms. Dandy, thank you for your presentation. I thoroughly enjoyed it, and we get a lot of calls in the branch about employment. So that's why I'm so keen to hear all the things that you're saying. So, and just so you know, we're trying to get people trained to call you first, but they seem to call the NAACP first. So, but again, thank you for your presentation,
Thank
and
you.
we will share as much information as you have to give us. And thank you, Tawana, also for bringing Miss Danny to the body.